thing about Juan Galt. He's not a troll. He's a well thought out, and most of his responses are well thought out.
And this video is also well thought out with real legal information. Although I've covered this subject before, I will go into more detail about prima facie evidence and burden of proof. Why? Because Stevens continues to lie and mislead people to sell his motions to dismiss, strike plea, remove the judge for bias, and for what Stevens sells as prosecutorial misconduct. What does Stevens say about my videos?
Anybody who says that I'm not being honest and that I'm wrong, 218-632-9399. Hell, I'll even schedule a live stream that we can do this on another day if you want to bring forth your evidence and show that that's not true.
Well, Stevens and I both know that that's a challenge to me. But instead of going on Stevens' show, where he controls the mute button, I will rebut him with my proof here. He can then produce his evidence to rebut mine, if he can. Now, I'm going to present real legal information that I hope Stevens and his victims can understand, since they lack real knowledge of the law. I will make it very simple. We'll start with Rule 301. Now, this is regarding presumptions and burdens. Now, why are we covering it? Because Stevens has convinced his victims of a lie, and that lie has to do with the burden of proof. As you can see, Rule 301 says, in a civil case, now this includes a traffic ticket, unless a federal statute or these rules provide otherwise. Now here's the important part. Look and listen. The party against whom a presumption is directed, that's Stevens and his victims, or whoever gets a traffic ticket, has the burden of producing evidence to rebut the presumption. Now that's totally the opposite of what Stevens sells to his victims. Because once you've been given a traffic ticket, you then have the burden to rebut that traffic ticket. And presumptions governed by this Rule 301 are given the effect of placing upon the opposing party the burden of establishing the non-existence of the presumed fact. Now, the presumed fact would be where you were, what you were seen doing, what time it was, what was said, what was heard, what was seen. And once the party invoking the presumption, that being the prosecutor, the cop, establishes the basic facts of giving rise to it. All right, and the basic facts giving rise to a traffic ticket would be the facts of what was seen, where you were, what you said, what you did, and what was witnessed. And like I said, the info on a traffic ticket establishes basic facts. Now next, I want to cover prima facie. Now this is very, 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 very important. And I want people to really look and read this, because Stevens is going to refer to prima facie evidence and burden as we go along. But this is what prima facie means in law, not in Stevens' mind or in Spoonerism, but in law. 1, prima facie is defined as something that has been proven or what? Assumed to be true unless what? There is evidence presented to the contrary. Stevens never produces any evidence contrary to the prima facie evidence by the prosecutor. 2, it's based on the first impression, and it's accepted as correct until proven otherwise. That's a traffic ticket, is accepted as correct until proven otherwise. Prima facie is Latin for at first look or on its face. referring to a lawsuit or criminal prosecution in which, what? The evidence before trial is sufficient to prove the case unless there is substantial contradictory evidence presented at trial. So there you go. Prima facie evidence is sufficient to prove the case unless Stevens and his victims present substantial evidence to the contrary. 4. In common law jurisdictions, prima facie denotes evidence that, what? Unless rebutted, would be sufficient to prove a particular proposition or fact. There you go. Remember these. Unless rebutted, because Stevens and his victims never rebut the prima facie evidence. 5. This is important. Prima facie evidence does not need to be conclusive or irrefutable. It doesn't have to totally prove everything beyond a reasonable doubt or preponderance of the evidence. Stevens will admit to this fact as we go along, but then he gets all confused because to make this clear to his victims, he couldn't sell motions. Now, at this stage, which is pre-trial, evidence rebutting the case is not considered. All that's considered is only whether any party's case has enough merit to take it to full trial. And 6, prima facie evidence is a legal term used to mean that you have enough evidence to prove something by pointing to some basic facts, but that your proof can be refuted. In other words, the basic facts are where you were, what time it was, what you did, what was seen, what was heard, what the cop saw and witnessed, etc. like that. That's the prima facie evidence. And once that is produced, that proof has to be refuted by Stevens or his victims. Now, then this is the burden for jurisdiction. Now, jurisdictional facts are unique, and they are unique from any other burden of proof. In other words, it's kind of like there's jurisdiction to determine jurisdiction, and jurisdiction has its own standard of proof. Specifically, if any factual or legal issue that a court must determine in ascertaining the authority of the forum, in other words, whether it has authority to hear a case, meaning whether as a matter of jurisdiction being challenged, service or venue being challenged, overlaps the merits, meaning that if, in Stevens' case, his position is the laws don't apply to him, and that's why he asked those questions. Well, that's considered by the court part of his defense or the merits of his case. So that would overlap his jurisdictional question. So when that happens, a lower standard of proof prevails for jurisdictional purposes, but not for merit purposes. In other words, to prove jurisdiction, it's a very, very low standard of proof. And what is this lower standard of proof? Well, here they are. This is the prima facie burden of proof standards that Stephen talks about. Has the prosecutor presented evidence to prove that jurisdiction and the laws apply to me? Okay, well, that standard of proof is not beyond a reasonable doubt or not even a preponderance of the evidence. Prima facie burden of proof standard starts with more likely than not. In other words, once a judge looks at the ticket with the statute on it and all the facts and witness testimony, he looks at it and says it's more likely than not that it's correct and true. Or it can even go lower than that to substantial possibility, all the way down to the slightest possibility that the information on the ticket is true. And if Stevens can't even put enough evidence forward to rebut a slightest possibility, then he has no proof. Now here's a little synopsis of it. I really want people to study this because you're going to hear this more and more as we go along, especially more likely than not. That's the prima facie standard for the burden of proof. The proof only has to prove that it's more likely than not that what is alleged is true. It doesn't have to prove it. And that's where Stephen confuses his victims and causes them to have to buy some of his motions because of the lies he tells about prima facie evidence. Let's continue. Now, these are the authoritative sources that I pulled my information from. There's some court cases. There's some treatises there. This is the information that Stevens does not have and his victims don't have. This you get from studying law, not studying Wikipedia. Take time and go over these every once in a while. And this is the proof that if Stevens can produce any evidence to rebut these authoritative sources, Stevens, you are now challenged to do so. But here's the bottom line on prima facie. It's clear that it requires less of a showing than required by the normally prevailing standard of proof. And the appropriate burden and standard of proof on personal jurisdictional issues of fact are the same in both state courts as in Nelson v. Miller, look these cases up, and in federal courts as in Val Leasing Incorporated, look that case up. Moreover, the burden and standard of proof on such jurisdictional issues, now look at this, are matters on which the judge is largely free from constitutional or statutory restriction. It's the judge's court. He makes the decision on what he will accept as admissible prima facie evidence. Now here's a real important question because Stephen makes a big deal about this. Significantly, the defendant in Nelson, like Stevens, contended that jurisdiction under the statutory words, now here it is, depended upon proof of all the elements necessary to spell out ultimate liability. Now that's what Stevens will tell you, that the prosecutor, is he proven all the essential elements of jurisdiction and of the crime because jurisdiction is an essential element of the crime. Wrong. The court rejected this contention, holding that the jurisdictional requirement was met when the defendant, personally or through an agent, is the author of the acts or omissions within the state, meaning you were the one speeding, and you were the one that the cop saw speeding. Okay, you've been given a quick lesson on what the standard is for the burden of proof for prima facie and what prima facie evidence is. So keeping everything you've learned up till now in mind of this real world legal knowledge I've given you, see if you can spot Stephen's misrepresentations and lies about prima facie in this slide we've got here.
Comes up. It is a trial issue to be proven beyond a reasonable doubt, but that's not always the prosecutor's burden. There's a prima facie burden.
Okay, now Stephen starts out correctly. There is the prima facie burden. Now, you know what that is, more likely than not. And you know that the evidence is more likely than not. So keeping that in mind, listen to Stevens.
Has the prosecution submitted sufficient evidence to prove jurisdiction to even have an arraignment, sir? Or you could just ask, sir, do you have evidence, or do you have jurisdiction to actually have an arraignment?
Yes, he does. Remember, prima facie evidence, and prima facie evidence is the ticket with all the information of who was there, where they were, what time of day, what conditions, what was seen, what was heard, what was witnessed. All of those facts make up the prima facie evidence, which tends to prove the presumption of a violation. So let's continue.
Well, yes, of course we do. Oh, is that because you say so or because the prosecution's evidence does? If they're having an arraignment against you, they have to have jurisdiction, right?
Mm-hmm.
And who has the burden of proving jurisdiction?
He does.
The prosecutor, not the judge, the prosecutor.
Mm-hmm.
The judge doesn't have a burden to prove. That's why I say when he insists on that there is jurisdiction, that's why I'll object and say, is that because you said so or because the prosecution's evidence does?
Now see, because Stevens can't recognize prima facie evidence that when it's presented, he thinks there's been no evidence presented. He thinks the prosecutor hasn't provided any evidence of jurisdiction whatsoever. But prima facially, he has. It's in the ticket. We all know that. So let's see what goes on now.
He does not have a burden to prove. And so if there has to be jurisdiction, and we know there does have to be jurisdiction to have an arraignment, we know that the prosecutor must present the evidence to support that conclusion and so that the judge can force you into an arraignment. If they're asserting jurisdiction, which is a claim of the prosecution, then they have to prove it. Do they have to prove it beyond a reasonable doubt at arraignment? No, but they have to have some evidence.
Some evidence. No. Prima facie evidence. And that's all they have to have at arraignment is the prima facie evidence of, more likely than not, the facts that are laid out in the ticket. More likely than not, they are true, and jurisdiction is established. So now Stevens or his victim, it's up to them to produce evidence to refute the prima facie evidence. But they can't because it's not there. Stevens, if you have any legal authority at this point that you can present to prove that what I'm saying is wrong, that the ticket is not prima facie evidence, and that the prima facie evidence of the ticket does not meet the burden of proof of more likely than not, produce it. You are now challenged to produce that in your next show. Let's continue.
To support the claim. And so it goes, is your physical location in Minnesota prima facie evidence of jurisdiction?
Yes. We've all seen that now. We know that where you are, everybody has to be somewhere, is prima facie evidence that it's more likely than not you're subject to the jurisdiction in that location. Let's continue.
What do you think?
No.
I don't think so either.
There it is. Stevens, being presented with prima facie evidence, doesn't recognize it. He doesn't believe that your location, where you are at a specific time and a specific place, is not prima facie evidence that it's maybe more likely than not the allegations in presumption of the rebuttable presumption on the ticket is correct. Now is the time for Stevens to present the evidence to refute the prima facie evidence, not to ask a bunch of dumbass questions that nobody has to answer. Let's continue.
Is it prima facie evidence that a written instrument called a constitution applies to you?
No.
No, because if we take it on its face, does the fact that you're physically in Minnesota prove that a written instrument applies to you?
Absolutely not.
So, is it prima facie evidence of jurisdiction?
Yes, see, we know that. We know what prima facie evidence of jurisdiction is, but Stevens doesn't. He's lying to his caller here, and he's teaching them something totally incorrect to where he'll get his butt in a bind and have to, or be convinced to buy some motions to file frivolous motions. Let's continue.
No, it can't be.
It can't possibly be in.
There it is. It can't possibly be prima facie evidence. There's no way in Stephen's world that it's prima facie evidence. And you and I now both know, after seeing all the evidence I presented, that it is prima facie evidence to say, if you're physically somewhere, that that's prima facie evidence that jurisdiction exists. And Stevens, if you have any legal authority that you can present as evidence to prove that what I'm saying is wrong, is a lie, you now have a chance to, or challenge and have a chance to rebut in your next show.
I would file a motion to dismiss for prosecutorial and judicial misconduct, and then and lack of evidence proving jurisdiction. I think it's important to ask that because it should be a very obvious question. Why is the prosecutor so confident in telling you they don't have to prove the foundation of their case?
Well, the prosecutor is confident that the prima facie burden for jurisdiction has been met. So he's not arguing without any evidence, or he doesn't have some special relationship with the judge, and he's not committing prosecutorial misconduct because he's confident, because he knows what prima facie evidence is. And see, this is where Stephen gets his victims all riled up emotionally so he can sell them some motions. Let's continue with this gibberish.
Are they just bluffing you? So that's why we ask that question. It's why I always ask that question. What is the nature of your relationship to this judge that you're so confident they're going to allow you to argue without evidence? Because isn't arguing without evidence misconduct, sir? So, put it, and they may say, look, we're done here. And so you're not willing to do whatever's necessary to resolve this without going to trial? Are you not going to work with me in a good faith effort to resolve this? You just want to send it to trial? See, that's another thing. They're supposed to do everything reasonably expected of them, to resolve the conflict without having to go to trial. That's what a pretrial is about. That's why you do discovery, so that you can narrow down the factual issues that need to be hammered out and settled at trial. And if he's not willing to do that, now you've got not only misconduct, now you've got him for bad faith.
Misconduct, well, we know that's bullshit. Bad faith, I don't know what the hell he's talking about. Never heard of such bullshit. But it gets his victims riled up emotionally, and that's all he's doing, so he can sell.
He's not willing to discuss the issues with you. He's just willing to shout at you like a child, I'm not required to prove that. I don't have to. Come on. And this is why I recommend, when you do the motion to dismiss for prosecutorial misconduct, which, yes, I do have a template that I'm happy to send you.
Well, of course you've got a template he's happy to send you for some bucks. See, he creates chaos in the victim's mind, but hey, I've got a solution.
You put those statements in there.
Yeah, he wants you to file, all right. We know why he wants you to file. Yeah, that's why. Okay, this is how and why a traffic ticket meets the prima facie burden of proof of jurisdiction, and without the prosecutor producing any other evidence. Okay, here's kind of a synopsis. A prima facie burden is met with prima facie evidence, and we've covered what that is. If prima facie evidence is considered correct and true, if the defendant cannot produce evidence to rebut the prosecutor's presumption based on said prima facie evidence. There you go. Stevens and his victims never produce any evidence to rebut the prosecutor's presumption based on the prima facie evidence. And when that happens, the judge will conclude there is jurisdiction when Stevens and his victims do not rebut. And asking a dumbass question that nobody has to answer is not a rebuttal. That's just setting yourself up for being ignored. And the trial will be set. Because asking the judge if the prosecutor has presented proof of jurisdiction, that's asking for legal advice. Why? Because it is the burden of the defendant, Stevens and his victims, to decide whether rebuttal of the prosecutor's evidence is needed. For Stevens to demand to see evidence beyond the prima facie evidence is out of order. Why? Because evidence beyond the prima facie standard is had at trial, not before. Now, I don't know. Both of these people kind of give me the feeling of ineptness. But there is that likeness, isn't there?
Go home, folks.